Good afternoon, everybody. Welcome to our series of lectures on ethical implication of AI. My name is Roberto Zicari. I'm the coordinator of this lecture series. We are now at lectures number 11 out of 16. Very happy to introduce you the speaker of today, who is Professor Florian Möslein from the University of Marburg. Florian will be covering one area that we did not really cover until now. We look at philosophy, we look at ethical principle, moral values, we look at some of the machine learning aspects, we look at trust, but one important area that is really linked together with the free, technical, and ethical is the legal aspects. And the legal aspects is really a hot topic at present. So we are extremely happy to have you here. Florian, the floor is on you. Thank you.
Many thanks, dear Roberto. I heard only half of your introduction, but I suppose it was very kind, and I hope that everybody can hear me now. And
yeah, we do.
Can also see my slides. Great.
Yeah.
Thanks for having me. What I'm going to talk about is the rules of the game, the rules that artificial intelligence is subject to, and that is a legal question, but it is not only a legal question. And what I will try to show is how different sorts of rules interact, and what kind of frictions and what kind of interplay that can create within, but also beyond the legal sphere. So even though my background is a legal background, my perspective today is much broader, and for lawyers, but I think also for many academics from many other disciplines, it is a very inspiring field to watch and to analyze, because it's a very dynamic field, and it's like a laboratory of rules that are developing. And that interact with technology, but at the same time are also subject of an interesting rulemaking process on various levels and with various players. And I will try to show you a little bit of those dynamics and introduce you to this regulatory framework. I will build on a paper that I'm about to write or about to publish, together with one of my assistants, Maximilian Horn, and it's going to come out later this year. So you will be able to read what I have been telling you today. I have modified the title of the lecture a little bit in order to make it more telling, maybe. Emerging rules of artificial intelligence, Trojan horses of ethics in the realm of law. That tells you maybe two more things than the official title of this lecture. On the one hand, we are talking about emerging rules that are just come into existence, just about to come into existence. So I'm not talking about traditional legal rules of liability or professional standards of care, but I'm talking about new rules that come into the field. And you can also see in the title that there's a interplay between ethics and law, which is far from being understood. It's a little bit like in the old Greeks age, but we will come to that. Given that here we are. Sorry, that was too quick. Let's go back. Here we are, Okay, given that AI and machine learning count among the key technologies of the digital age, the debate on whether and how to regulate this technology raises some of the most fundamental current questions of legal policy. In fact, these issues are intensively debated and are particularly controversial. In Germany, for instance, two key institutional players have taken fundamentally different views on the subject matter. On the one hand, the influential initiative T21 Germany's largest non-profit network in the field, dedicated to a digital society and comprised of key actors in business, politics, civil society, science, and academia, prominently rejects the introduction of any new regulations for algorithms. On the other hand, the Data Ethics Commission, a group of 16 independent experts, one of them will, by the way, be part of this lecture series at some later point. This Data Ethics Commission has been created by the federal government, and it, I cite, holds the view that regulation is necessary and cannot be replaced by ethical principles. So on the one hand, we have a plea for or rejection of new regulations. On the other hand, we have the argument that regulation is needed. These two positions seem to imply that an either-or decision needs to be taken with respect to AI, either ethical principles or legal regulation. So it seems that those are two different sorts of rules, and you can choose either one or the other, but not both. And moreover, they don't seem to relate to each other. At least both the D21 initiative and the report of the Data Ethics Commission are based on the understanding of ethical and legal rules as two entirely different categories, two categories that neither overlap nor interfere with one another. This lecture today will query the understanding and argue that ethical guidelines and principles may in fact bring about significant legal implications, despite their ethical branding. If this is true, it seems in fact misleading to disguise rules as purely ethical principles, because this hides their effective relevance and their impact. The relevance of such potential hardening of soft ethical principles cannot be overstated, given the current emergence of a multitude of such guidelines on artificial intelligence at various levels and by different players. While all these rules concern artificial intelligence, that subject matter is far from being well defined. There are only very few definitions of that term, which are already enshrined in legal provisions so far. In legal discourse, many other terms are in fact being used: robots, autonomous systems, machine learning, algorithms, and also artificial intelligence. All these terms relate to technologies that are rapidly converging. They have similar meanings, but they are defined somewhat differently. One important element certainly concerns the distinction between algorithmic, deterministic behavior on the one hand, and autonomous behavior on the other. The latter is enabled by machine learning and cannot be foreseen, and therefore, and that is important from a legal perspective, therefore causation is difficult, if not impossible, to establish. You cannot foresee what the machine is going to decide. Given that it relates to causation, this is crucial from a legal perspective, because law, if it comes, for example, to liability questions, the key argument is always whether this damage that has been caused by some human being, and it is crucial in order to win legal proceedings to establish some link, and that's what we lawyers call causation. Now, the very few legal definitions of artificial intelligence, however, do not relate to this distinction. And I cite one example here, the legislation of New Jersey. It makes a comparison with human behavior. This is a bill that has been introduced in the US Senate. At the bottom of the slide, it is somewhat more explicit than the New Jersey legislation, but in substance, it takes a very similar approach. And both of these laws don't refer to the question of causation, even though it is so important in other legal fields. Now, even if there is no precise definition of the subject matter, our current economy and society increasingly face a multitude of applications of artificial intelligence. Beyond Facebook, Google, and Amazon's algorithms, robo-advisors take investment decisions, robo-lawyers give automated legal advice, and robo-directors in companies are in charge of business decisions in these organizations. Of course, these robots have not replaced human advisors, lawyers, and directors so far, but what they are doing is that they increasingly support and assist human decision-making. Decision-making in these fields has always been subject to various legal rules in terms of securities or professional or company law rules. With the rise of AI, the question arises how these traditional sector-specific legal rules can be applied if, for instance, robots assist or even replace humans, if artificial intelligence is used to assist human decision-making. For instance, how do rules that specify the duties of directors in companies, how do these rules apply if business decisions are not taken by human directors, but if they are decided by AI technologies? So far, there is no respective case law on this question. We lack any respective legal experience simply because the technology is entirely new and disruptive. However, we will soon face new cases which will raise those precise key questions in a wide range of different areas. In order to decide such cases, judges may think of following new guidelines that are currently about to develop, namely rules on artificial intelligence. These rules are, as opposed to the traditional legal rules, are not sector specific, however, but they are technology specific. And they are typically not enacted by legislators, but by various other rulemaking bodies at different levels. The remainder of today's lecture will give you an overview both on the variety of these rules and on their substance, but also it will discuss their legal relevance, the legal relevance of these technology-specific extra-legal rules, both in general and with respect to some specific examples, like robo-advisors or robo-directors. Now, let me first come to the variety of rules that are emerging, the rules that I'm going to talk about in the remainder of this lecture. And if I look at these rules, I will distinguish between the international level, the European level, and the national level in order to structure the overview of these various sets of rules. To start with, on the international level, different institutions and bodies are currently discussing and negotiating the need for regulation in the field of AI. There are various AI-related initiatives of both the G7 and the G20, the United Nations, and in particular the OECD. However, it has not been possible to establish some universal, generally accepted guidelines yet. More specifically, the G7 Ministerial Conference issued a declaration on AI in March 2018, 2 years ago. This declaration served as the basis for a multi-stakeholder conference which tried to foster social trust in AI and evolve a joint vision of human-centered AI. Moreover, Japan, the host country of the G20 meeting in June 2019, has put AI on the agenda of the G20. The United Nations, on the other hand, established an agency to monitor developments in the field of AI worldwide, the so-called UNICRI Center for Artificial Intelligence and Robotics, based at The Hague. Within the scope of the AI for Good global summits, they also analyzed the potential of AI technologies with regard to global sustainability and developed strategies both to ensure a trustworthy, secure, and integrative development of the relevant technologies, and also to safeguard equal access. However, despite these efforts, almost no specific regulations have emerged from these various activities. A more specific and more elaborate regulatory instrument has recently been published by the Organization for Economic Cooperation and Development, the OECD, namely the recommendation of the Council on Artificial Intelligence, which is nearly on the day today 1 year old. It has been published on the 22nd of May 2019. In fact, this recommendation established the first formal recognition of AI principles by a large number of governments. In addition to the 36 member states, 6 other states have also signed the recommendation, Moreover, the final declaration of the Osaka summit, the summit in Japan, expresses an endorsement by all G20 member states. So it's not only an initiative of the OECD, but it is backed by the G20. In addition to the actual principles, the document also incorporates 5 political recommendations, for example, to facilitate AI-related investments or to promote corresponding ecosystems. The principles have been developed since September 2018, and they were drafted by a group of more than 50 experts, in part representatives from governments, in part exponents of business, labor, civil society, and also academia. Recommendations of the OECD are not legally binding, but they often have established the basis for the development of international standards in the past, and they have also served as guidelines for governments when drafting national legislations. So formally, these guidelines and also this recommendation of 2019 do not have any binding effect, but they often serve as a example that is followed by many national governments and also by the business itself. Due to the competence of experts involved and due to formal governmental support, one can also expect that the 2019 OECD AI recommendations will have a significant impact in the future, comparable with that of, for example, the 1999 OECD corporate governance principles. Now let me come to the European level. At the European level, a high-level group of experts on artificial intelligence was established by the European Commission in June 2018. It had 52 members, also representing a wide range of stakeholders. 6 months later, in December 2018, the group published a draft on ethics guidelines. After intensive consultation and exchange with representatives of the member states, these guidelines were then released on April 8, 2019 in a revised version, so almost parallel to the OECD guidelines. The European guidelines are being evaluated in a piloting process. In terms of content, they set out requirements for trustworthy AI. They also discuss various technical and non-technical options as to how these requirements could be implemented and evaluated, including questions of regulation, standardization, and also certification of AI. On the other hand, the drafters of the guidelines put emphasis on the non-mandatory character of the guidelines. They stress that they merely formulate ethical standards and requirements for the technical robustness of AI systems. I cite, the guidelines do not explicitly deal with the first component of trustworthy AI, namely lawful AI, but instead aim to offer guidance on fostering and securing the second and third component, namely ethical and robust AI. So these guidelines explicitly mention that they do not want to change the law. Similar to the OECD recommendations, it is nonetheless likely that the guidelines might have a significant impact on the legal assessment of artificial intelligence. With its communication on building trust in human-centric artificial intelligence, which was published at the same time as the guidelines, the European Commission itself underlined the guidelines' key requirements, albeit using partially abridged and revised wording. So the wording of this communication is not the same as the report of the high-level expert group, but in substance, it's very, very similar and backed by the European Commission as a political entity. Although the European Commission clarifies once again the non-binding character of the guidelines, it also attributes them an important role on the way towards international AI ethics guidelines. It even claims a leadership role in developing international AI guidelines, for instance, with respect to, I cite, relevant standardization activities in international standards development organizations. The Commission thereby clearly aims at developing international standards on how AI is used and how AI is developed. Against this background, the future impact of these guidelines, or at least of the rephrased key requirements as formulated in the Commission's communication, must not be underestimated. Now, the third level is the the national level. At this national level, some legislators have been more active, others have been less active, and I just want to draw your attention to one example. The German legislator has not yet provided any general sets of rules on AI, apart from some technology and industry-specific provisions. For instance, one specific provision is found in the German Securities Trading Act. It concerns algorithms. In its section 80, the law, which has been introduced in 2013 already, contains a provision on the prevention of risks and the abuse in high-frequency trading, and that regulates algorithmic trading in financial instruments. Though it covers a field where AI plays a certain role. But it's a very specific rule. It only has relevance for this market in financial instruments. It provides for a number of individual duties that investment service providers engaging in such trading activities have to follow. Whether or not these rules also apply by analogy to other AI applications is subject to controversial discussion. For instance, those who provide robo-advice or robo-investment advice or other robotic services do not really know whether these rules can be applied by analogy. At least the organizational requirements that are laid down in this specific provision are comparable to those incorporated in the international and European AI guidelines. In order to comply with these requirements, investment service providers must ensure that respective systems are designed in a technically reliable way. They must be stable. For example, the systems must provide for precautionary measures in case of technical failure. Secondly, the systems must provide for permanent and for effective arrangements against misuse in order to ensure that no irregular practices take place. Thirdly, investment service providers using such systems must be able to understand and to control the respective algorithms. Finally, the provider must also document each individual modification. And these are rules that, at least in substance, can be found in other areas as well. We will always find some duties to document AI applications. We find duties to understand and to control this technology, and also the duty to take precautionary measures to safeguard the proper functionality of this technology. On a somewhat broader level, the federal government of Germany has recently announced future AI-specific regulatory initiatives in its artificial intelligence strategy of November 2018. For example, it indicated its intention to review the legal framework concerning regulatory gaps regarding algorithm and AI-based decisions, services, and products, if necessary, also to adapt these rules and make them verifiable with regard to potential unlawful discrimination. The federal government paid particular attention to including ethical standards in the entire development, testing, and application process of AI systems. It explicitly refers to ethics by, in, and for design to these approaches that are well known to computer scientists. However, it hasn't yet defined specific standards. That said, the government has at least revealed its general intention by announcing that studies will be carried out to establish the transparency, the traceability, and the verifiability of AI systems in order to provide effective protection against distortion, against discrimination, manipulation, and other abusive uses, especially when algorithms are used to forecast and to make decisions. By this token, the German federal government's initiative takes the principles of European ethics guidelines into account. In 2018, the German federal government had already appointed the Data Ethics Commission that I have already mentioned, with its mission to provide recommendations for action and propose regulatory options. In addition, technical and industry-specific sets of rules have been developed. For example, guidelines for programming automated driving systems, as elaborated by the Ethics Commission for automated and networked driving. Now, in addition to these state activities at various levels, a number of individual companies have also developed sets of rules dealing with AI. Business and other stakeholder associations are working on similar rule books. Recent examples of such regulatory activities are, for instance, the quality mark of the German Artificial Intelligence Association, Bundesverband Künstliche Intelligenz, the guidelines of the German Digital Economy Association, Bundesverband Digitale Wirtschaft, and on an international level, the global policy framework of the International Technology Law Association, all of them published in spring 2019. In summary, this overview of regulatory activities at various levels demonstrates an extremely dynamic development of standards and other normative measures. This process is resulting in a correspondingly wide range of different AI guidelines. And it is, at first sight, somehow confusing how many different rules at different levels are coming into existence. And therefore, first steps have been taken to categorize and to systematize these various sets of rules. And one example for this is an initiative by the Berkman Center for Internet and Society at Harvard University. They have begun to map a variety of regulatory approaches that I have printed on this slide. And it tries to give you an overview of it's very. I am aware that it's very small, so you won't be able to see everything. But the idea is that this map shows various rule books and also shows the strengths and weaknesses or the focus of these rule books. So, for instance, in yellow you see rules that relate to civil society. In green, you see rules that relate to the government, and so forth. And the dots are either small or bigger, relating on which principles are mentioned in these various rule books. So, for instance, the privacy is the inner circle, and then come principles on accountability, on safety and security, on transparency, on fairness, and so on and so forth. So this shows really in one slide both the variety of rules, but also their substance and the focus of all different rules that you can see in this circle. More specifically, both the OECD principles and the EU initiative can be regarded as attempts to recapture those various ongoing regulatory dynamics in the field of AI, which were previously dominated by entrepreneurial self-regulation. Those are also attempts to steer rulemaking towards a more comprehensive approach, both in terms of content and scope, but also towards a more official, sovereign character. Now, this was the first part of my lecture, which tried to show you like the map of rules, of different rules that exist. Feel free to ask questions at this point, but you can also ask questions at the end as you like. If you don't have questions at this point, I would continue with the substance of all these rules. And I try to show the common core of substance. I won't go into detail of all different rule books, but I will try to show you what these different rule books have in common. In order to describe the substantive content of these emerging regulatory regimes on different levels, it is sufficient to consider solely or to focus on the OECD principles and the European Union initiative. Due to the political importance of the respective rulemakers, these two regimes are likely to gain the most significant influence in the future. Furthermore, in light of the considerable substantive similarities of these two regulations, they can be examined together, notwithstanding specific differences in detail. The key regulatory principles that are contained within these two regimes form, moreover, part of many other principles, as the mapping exercise of the Berkman Klein Center clearly illustrates. Already, the respective definitions of the term AI are similar in both sets of rules. they also define the substantive scope of application. In the preamble, the OECD principles describe AI systems as any, I cite, machine-based system that can, for a given set of human-defined objectives, make predictions, recommendations, or decisions influencing real or virtual environments, regardless of the specific level of autonomy, which may vary. As the starting point of the EU initiative, the Commission defines the concept of artificial intelligence in a very similar way, namely as systems that display intelligent behavior by analyzing the environment and taking actions with some degree of autonomy to achieve specific goals. Furthermore, this text clarifies that these systems can be both software-based and also embedded in hardware. The more precise definition suggested by the expert group in its guidelines is even more in line with the OECD principles. So both definitions, both set of definitions, have several elements in common, including first, the technological basis, machine-based or software supported or embedded in hardware. Second, the finality, the complex goals that are defined or determined by humans. The third element refers to the potential influence of the systems that are concerned, which may impact on the real or virtual environment or goal orientation. In addition, both definitions do not determine to which degree the respective system must be able to act autonomously to meet the definition's requirement. However, since the wording of either definition requires a minimum degree of autonomy, deterministic systems are likely to be beyond the scope of these rules. With regard to the forms of action executed by artificial intelligence, the OECD principles list predictions, recommendations, and decisions, whereas the EU Commission refers in a less specific way to analysis and action, but both are largely similar. So these are the key elements of the definition of AI that are similar in both sets of rules. In substance, the rules that are found in these two sets of rules can be grouped into four main areas. And the first area relates to control and controllability of the technology. These rules include the fundamental principle of granting priority to human action and supervision. Such requirement of human agency and oversight is particularly emphasized by the European Commission. Likewise, although less emphatically, the OECD principles mention the requirement of human centricity. This principle is particularly important because it defines the relationship between human and technical autonomy by subordinating the latter to the former in order to give fundamental priority to human action and human values, including the rule of law, human rights, and democratic values. Depending on the respective circumstances, however, it will often be difficult to decide which degree of autonomous decisions relating to AI is in accordance with this principle. For instance, in order to comply, does each decision made by an AI-driven robot require human supervision, or does that requirement depend on the amount of money that is at stake, or is human involvement with a single operative decision totally unnecessary? Is it sufficient if humans decide on the fundamental strategy? The Commission distinguishes between the concepts of human in the loop, human on the loop, and human in command, each of which represents a different degree of human involvement in AI decision making. This distinction tentatively signalizes that overall human control is in general sufficient. If this were the case, a purely machine-based decision to invest in a comparatively small company, for instance, would still be compatible with the basic principle, whereas a purely machine-controlled strategy would not comply. Second, the principle of technical robustness and safety can be conceptualized as the other side of the coin. Formulated almost identically in the European and the OECD rules, it stipulates that there must not only be the possibility of human supervision, but that human actors are responsible for the respective technical system and that they are required to ensure the reliability of these systems. Basically, the principle obliges providers of AI technology to take precautionary measures that protect the system in use against technical attacks or manipulation attempts, to install risk management systems, which include integrated protective measures, and to adequately document the technical safety. With regard to other high-risk technologies, comparable requirements concerning robustness and safety are well known, and they are also stipulated within legal guidelines, for instance, legislation relating to nuclear energy. So this is nothing new as a legal principle. It is only expressively mentioned for AI here. As mentioned previously, the same applies also to algorithmic trading, for instance. The conceivable consequences of a potential default or even crash of large computer systems are likely to be as far-reaching as the same risks stemming from other high-risk technologies. On this basis, one can argue that in favor of the application of similar general guidelines for AI technologies. Now, the second set of rules relates to disclosure. Supporting this obligation to document technical processes for verifiability and for traceability purposes, this other set of requirements deal with issues concerning disclosure, that is, informing other parties on AI and on how AI works. This includes the principle of transparency and explainability of AI systems. This principle requires providers not only to record and document algorithmic decision processes, but also to explain these processes to the persons involved in a comprehensive manner. According to the European Commission, the provider's duty to safeguard explainability of the algorithmic decision-making process is meant to ensure not just data and system transparency, but also business model transparency. Taking the example of providers of robo-advice, for instance, an obligation of such disclosure entails far-reaching consequences, as it basically requires detailed explanations of the investment calculations and risk models that underlie the robo decisions. Such disclosure of business models would affect the provider's right to protect business and trade secrets. That right is not only of crucial importance to the competitive markets, especially in the financial sector, but it is also expressly protected by the European Trade Secrets Directive. It therefore may be assumed that due to these conflicting legal provisions, the respective principle is limited to a duty to explain and thereby disclose processes that are merely to the extent possible or as far as the concerned information is relevant and adequate. Secondly, accountability for AI systems. As defined both by the OECD principles and the European Commission, this accountability builds on disclosure but goes beyond disclosure. It also requires providers to take responsibility for AI systems. Moreover, it necessitates their verifiability, for example, by involving internal and external inspections by auditors. The principle specifically aims at evaluation, documentation, and the minimization of potential negative impacts of AI systems. Accountability has, however, no specific substantive content. It is rather an instrument to ensure the enforceability of other more substantive obligations by serving as an effective procedural mechanism. In this vein, the EU Commission simply stresses that it aims at foreseeing accessible mechanisms that ensure adequate redress. And this formula shows already a certain link to the legal sphere. The third set of rules after disclosure and after control and controllability, the third set of rules relates to safeguarding individual rights. As opposed to the aforementioned accountability principle, the requirement serving the purpose of protecting individual rights is of a more substantive nature. While the OECD principles enumerate, I cite, freedom, dignity, and autonomy, privacy, and data protection, non-discrimination and equality, diversity, fairness, social justice, and internationally recognized labor laws in this respect. End of citation. The European Commission's communication solely focuses on privacy and data governance and diversity, non-discrimination, and fairness when it comes to protecting individual rights. Its communication, on the other hand, goes into much more detail regarding these two aspects. For example, it requires AI providers not only to act in accordance with data protection provisions, but also obliges them to guarantee the integrity of the data used. Furthermore, this communication deals with questions concerning regulation and control of access to data. Such stipulations might imply far-reaching consequences for AI applications in practice, since they are likely to apply not only to customer data, but also to market data and information on various instruments. Accordingly, providers must ensure that they do not rely on data that contains inaccuracies, errors, and mistakes. The requirement of diversity, non-discrimination, and fairness, on the other hand, amounts to a duty to avoid unintentional data-biased distortions. In the field of robo-advice, for instance, providers could infringe this principle if they coincidentally overemphasize domestic financial instruments or shares in a particular sector. By this token, the principle also interacts with the duty of loyalty of asset managers. Similar effects may arise in company law with respect to directors' duties. As a consequence, specific rules relating to AI and sector-specific provisions on equal treatment may overlap and interfere with each other. They may even clash if, for example, only the corporate law duty of loyalty of asset managers provides for exceptions in specific cases. Finally, the principle also concerns the internal organization of AI providers, for example, by calling for the formation of diverse design teams and the establishment of mechanisms ensuring participation. So that goes very much into the internal organization of those who provide AI technologies. Now, the last field of contents of these rules relates to public good requirements. Both sets of rules, the OECD one and the European one, are not only aiming at guaranteeing individual rights, but they also take into account the potential societal and environmental impact of AI systems and providers. The OECD principles, for instance, state that shareholders should proactively engage in responsible stewardship of trustworthy AI in pursuit of beneficial outcomes for people and the planet, thus invigorating inclusive growth, sustainable development, and well-being. So these are really requirements of public good. And similarly, the EU Commission calls for the encouragement of sustainability and ecological responsibility of AI systems, as well as the consideration of their social impact. Of course, these principles are very vague, very vaguely formulated, but their potential effects with regard to specific questions might be very, very intrusive. For instance, do these rules result in a duty to express a preference for sustainable corporate strategies or for sustainable decisions? Are AI providers obliged to offer services also to disadvantaged groups, AI for everyone? If the answer to these questions were yes, the consequences would be really far-reaching. For example, the requirement of a minimum investment, as is very common for robo-advisors, seems very questionable in light of these social effects and social requirements. Such requirement would even be discriminatory in the sense that no such restrictions apply to traditional human advisors or corporate directors. So this last set of principles is very far-reaching, it's very vague, but at the same time, it's also very intrusive. Now, if you don't have any question on this point, I would continue with the last and a bit shorter part of my lecture.
Actually,
and now,
Florian, there are questions. So if
there are questions, even better.
I didn't interrupt you because there are a number of questions, so maybe I can read a few of those if
That
you
would be
if you
fine.
wish.
Go ahead.
Yeah. Okay. So there's a question from Yvonne, who, by the way, is a lawyer, so I know her. And she asked, who is responsible when AI operates, for example, in the battlefield, so in the military? The provider, such as Airbus or Rheinmetall, the commander, the National Department of Defense, which is running a hybrid troops consisting of AI, robots, and human soldiers.
Many things. That is precisely a question that refers to the causation link that I have mentioned at the very beginning, and therefore it is a question that can only be answered by the legal framework, not so much by the ethical rules that I have been describing over the last 20 or 30 minutes. From a legal perspective, it really depends on showing and on proving that the specific person in question caused the harm. So if you have some sort of harm that has been happening in the battlefield, you need to establish a link to the wrongdoing of one of these persons, the provider of such as Airbus, the commander, the national department, and so on. Now, the real problem is that AI makes this causational link very difficult to establish, and it is very difficult to prove that there's some human being behind the AI that can be really made responsible for these actions. But interestingly, all these sets of rules that I have been describing, they describe very fundamental principles, but they do not help with this responsibility question. So that is the bottom line. Why it makes sense to switch to the legal relevance in a second step.
Yeah, thank you, Florian. So if you want to take a couple more questions, I have a couple more. There's a question from Emily, I think from France. She's asking, the human control issue that you were talking about raised an important question about our education system, I would think. Who will be the humans who have the expertise and knowledge to oversee and control AI? Will we promote general AI literacy for all in society, or will it be in the hands of a few experts? Will there be gender or other bias to consider? So the number of questions connected to the same topic.
Mm-hmm. Mm-hmm. So this is really a question on the competencies that humans need and will need in future. And I think we are just at the starting point, and precisely this lecture is an example of that. We need to combine technological knowledge with ethical knowledge, but I would argue that this is not enough, because even if you educate people in a proper way, you won't exclude the possibility that they will behave differently, and therefore you still need that legal background in order to control that no wrongdoings are going to happen. So yes, education is an important element, but it won't be sufficient, and therefore the question that I'm asking is relevant and indeed crucial.
Yeah, thank you, Florian. Let's take the last question. I have more, but I mean, we want you to
all my excuses. I didn't have the chat opened, and I'm quite surprised to see all these questions here now. So I didn't follow them during my talk.
No, but
I'm happy
good.
to take another one.
I'm moderating the chat, so it's good, so you don't get distracted. So I have a question from Alex. He mentioned an hypothetical situation that is the following. In the future, it will be possible to add AI technology inside to the human body. So that's an hypothesis. The formulates. Person one, improve his brain power with AI. Let's assume that is going to happen. If this happens, is a person and the AI now judged as one entity in a legal sense, or will the AI and the person judge each of them separately? What is your opinion?
Thank you so much. That's an interesting and intriguing question, in fact. But I think the answer is quite similar, or quite simple. Under our current legal system, legal entities are only humans. There's one exception, that corporations or some sort of organizations are also given the status of entity in a legal sense. But technology, such as AI applications, do not have the status of legal entity. And this is precisely why causation questions are so difficult, because you cannot attribute liability, for instance, to AI applications. So you always have to trace back to the humans that are active behind the AI applications. If you think of this, it does not really make a difference whether humans use AI applications in order to take some decisions, or whether the AI is built into humans, because the legal system still builds on the humans and does not really look on the tools and the technologies that they are using, regardless of whether these tools are in the body or out of the body. The only question that could then arise is, at a point where the humans are no longer able to decide on their own will. So take this example a bit further. If you implant AI technology into a human being, thereby excluding an own will of this person. So AI really takes all decisions of that human being. Then you could, of course, argue that the human being is no longer a legal entity because it is not able to take its own decisions. But that seems very visionary to me, and I'm not aware of any cases so far, or any legal discussion on that point.
Okay, Florian, thank you. We'll let you continue, so we'll collect other questions at the end.
Okay, so thank you so much. The last, and I think the most interesting and relevant part of my lecture is now really, what is the impact? What is the role of these various sets of rules that I've been mentioning? I have said that they are called ethical principles, but what does that mean? And this brings me to a very fundamental question. And this fundamental question relates to the character of rules, to the distinction between legal rules and ethical rules. Now, there have been discussions on these distinctions for centuries, and even in the old Roman age, because law and ethics have many similarities. Both are based on rules. Both are similar, often similar in substance, and both have similar aims. But what is really a difference between law and ethics is the mode of enforcement, the means of enforcement. Whereas ethical rules are sanctioned by social sanctions, legal rules are sanctions by legal sanctions, and that is a big difference because social sanctions are limited to reputation. So if somebody in a community behaves unethical, what can happen is that people say, well, he doesn't behave properly, but you cannot go to court, you cannot enforce a compliance with ethical rules. On the other hand, if a person is in conflict with legal rules, you can either have a public authority like the police or a judge that enforces compliance with this legal rule in question, or you have private remedies. another person who claims liability because of misbehavior. For instance, in cases of violation of certain rules, either another private party, another human being can bring a claim, or a public authority can impose penalties. So the real question now is, what happens if the rules that I have been described, the rules of these various rule books, if those rules are violated? Take the example of an artificial intelligence application that discriminates against women or against colored people or against foreigners. Of course, this does not comply with the non-discrimination rules that I've just described, but that is not an answer to the question. The question is, what happens then? What happens in case that we can establish that an AI application is not in compliance with these rules? And that is a very real and a very relevant question, because you are probably all aware of all the discussions and all examples of algorithms that discriminate. To begin with, Google's algorithm, and there are examples in human resources. There are examples in the penal area where criminals are concerned. So in a very various different examples, we will face these questions. And if the rules that I have described are only ethical rules, then the only sanction would be a loss of reputation. The provider of AI or the people who use this AI might be no longer well regarded because they did not comply with these rules. On the other hand, if those rules had some sort of legal quality, the people who have been discriminated against could claim damages, or public authorities could step in and could impose penalties on those providers of AI. So the dividing line between ethical rules and legal rules is really of great importance, because it has fundamental impact on the question how you can enforce these rules. And that is, in the end, something that makes rules important or less important. Only if you can enforce rules, they are really relevant. Now, from a formal perspective, the classification of all these rules that I've mentioned and described seems quite obvious. OECD rules are of a non-binding character, and also EU recommendations are of a non-binding character. And even the wording of these rule books explicitly state that the rules are non-binding. For instance, in the EU Commission communication, it says that they are non-binding and as such do not create any new legal obligations. So it seems that those rules are purely ethical and thereby very restricted in their enforceability. However, I mentioned the claim to establish international standards, and I also mentioned the expectation towards member states or towards nations to take action. So these international bodies explicitly say that the rules do not create any legal obligations, but on the other hand, they expect that they are that they will develop into something that might be enforceable. My argument would be that already by now, these rule books have some implicit legal relevance. In legal theory, we used to distinguish between proper sources of law and sources of legal knowledge, Rechtsgeltungs- and Rechtserkenntnisquellen, and only the former form part of the legal system, whereas the latter can be used in order to understand and interpret legal rules. And that's something we also observe in many other areas, that so-called soft law rules harden over time, that they develop into something that can be enforced. And what I really expected that these rule books will harden in a similar way. And the reasons for this hardening of soft law that is to be expected is that lawyers, judges, and other people active in the area of law simply don't have any experience with AI. And whenever you don't have experience, you need some sort of guideline, and you will orient along these guidelines. And of course, these international rules are some guidelines that can be accessed and that can be consulted by the various actors in the legal field. Therefore, if new category of cases come before the courts, discrimination by AI, for example, then the judge will be inclined to look not only at the law, but whenever the law leaves a question open, the judge will look at these guidelines, even though they are not legal in a formal sense. In fact, this observation is explicitly stated in the EU communication. It says, finally, when unjust adverse impact occurs, accessible mechanisms should be foreseen that ensure adequate redress. This is a very brief sentence, but it makes clear that a loss of reputation, that social sanctions alone do not seem sufficient to the EU, and that the EU really wants to develop those ethical rules into proper legal rules, because only this will ensure adequate compliance. Now, to come to a conclusion, the distinction between law and ethics is crucial. Formally, the rules have no legal force. Implicitly, they have some relevance, and therefore, I expect those rules to develop into legal standards, and this will happen whenever proper legal standards are concretized. Take directors' duties, for example. They are very vaguely formulated in the law as duties of care and loyalty, similar in the banking and then in the professional law. And whenever judges will have to analyze whether a specific behavior of a director or of an investment advisor or of a lawyer complies with these legal duties, the judge will be inclined to look at the more specific rule books, even though those are not of a legal character. Take the example of AI used by a company director in order to take some business decisions. The standard of care is written down in the law, but it is not clear whether the use of artificial intelligence complies with the standard of care, and then the guidebooks and the guidelines will help the judge to identify whether there has been a violation of the standard of care. Similar with respect to disclosure, the information rights of shareholders are laid down in corporate law, but they do not say much about, or they do not say anything about the necessary information on the use of AI technologies in the company, and therefore they will be complemented. These corporate law rules will be complemented by the extra legal rules that we find here. On my last two slides, I have elaborated a bit on company law and on robo-directors. So the question is really, which liability do board members have if they delegate certain decisions to AI? That depends largely on the scope and on the intensity of their duty to monitor. In most jurisdictions, however, this oversight duty is not very well defined. In German law, for instance, courts often refer to circumstances of individual cases. This approach is often criticized as an empty formula, and even the more specific provisions of corporate law do not help much. Therefore, this regulatory gap will be overcome by taking other rules into account, either legal rules in other contexts, in other areas of law, Or the judge might take a look or have a look into extra legal rules, for instance, in these generally accepted rules of conduct. And of course, these rules of conduct, even if they are only ethical rules, they have a very high standing because they are written by governments. They are written by the OECD. They are written by the members of the European Union, and therefore they have a very strong standing, even if they are not legal in the proper sense. So judges will often be inclined to take them into account. And similar considerations apply to securities law. When robo-advisors take investment decisions, there is, of course, a general principle written down in the law to act honestly, fairly, and professionally in accordance with the best possible interest of clients. But this formula alone shows you how vague the legal provision is. And if a judge needs to decide whether a specific investment decision has been taken honestly, fairly, and professionally in accordance with the best possible interests of clients, it will be very difficult to answer that question, in particular when the question has been taken by AI technologies. So these very vague words of honesty, fairness, professional conduct, best interest will be filled by the principles of these ethical guidebooks that I have mentioned. And the same applies to other more specific requirements of securities law, but I don't want to go into detail here. What I want to do at this point is to conclude, and I'm happy to take further questions after that, but to conclude by showing you this picture. Legal and ethical rules are often conceptualized and understood as two entirely different categories. But I think the example of AI shows us that they can interact very closely with each other. And one should not underestimate the legal relevance of ethical rules on AI. And therefore, I had taken this picture of the Trojan horses in the title of my presentation today. Do not trust the horse, Trojans, whatever it is. I fear the Greeks, even if they bring gifts. In a similar way, the rules that I have shown are branded as ethical rules, but I think in reality they will come out as something different. Namely, they will come out as legal rules to some extent, at least. Thank you so much for your attention, and looking forward to your further questions.
Thank you, Florian, for the very interesting presentation. Yes, there are questions. So let me just read a few of those.
Oh, yeah, there's a whole lot of them.
Yeah. Let me just speak some of them. Let's start with Yvonne. As I said, the background, she's a lawyer in business. She's asking, but isn't it the case that corporate ethics, corporate social responsibility is soft law that can face hard facts when violated? You mentioned something about that, but you want to comment on this question?
I'm more than happy to comment on this question because, in fact, those rules on corporate social responsibility are very similar, and that's maybe even the prime example. Of course, corporate social responsibility has a different aim, a different purpose. It concerns social behavior, it concerns environmental impact of companies and also social impact of companies. But the mechanism on how rules develop is similar, namely in the sense that you have first soft law rules, some expectations on companies, how to behave. And over time, these expectations develop into proper legal rules that can be enforced in the way that I have been described. So this is a prime example of the hardening of soft law. And I think we will be able to observe a similar development in the field of AI that we are discussing today. I expect the development to happen even more quickly than in the field of social responsibility, because the guidelines, the rule books, are of a much more formalized nature. They have been written by the OECD and by the European Union, so they have a very high standing. The risk of that development is, of course, that they are not enacted as proper legal provisions, and therefore they are not controlled in a similar democratic way as legislation. They cannot be tested in constitutional courts, for example. So they sound very nice. They sound very good, but I am a bit suspicious of this way of lawmaking because it's a very not a very obvious and not a very transparent way to make laws. It's a little bit like Trojan horses, that you introduce some principles that you say those are just ethical principles. You don't have to justify these principles, but over time they develop into legal rules, and they become much more forceful than before.
Yeah, thank you, Florian. One of the presentations that we had previously was focused on trust and AI. And also the European Commission is mainly focused on trustworthy AI. They don't talk about ethics AI, they talk about trust. How would you relate trust to ethics and law?
That's a very fundamental, almost a question of legal theory. I think trust has much to do with reputation. In order to create trust among a certain community, you need to comply with ethical standards. So the idea of ethics and the idea of trust are closely related. To put it the other way around, if you are in conflict with ethical rules, you will soon lose trust, or the trust in your in what you're doing will soon be lost. Therefore, I don't think it makes a big difference that the EU talks more about trust than about ethics. I think the idea is much the same. So trusts and ethics belong in the ethic category, whereas the legal category is related to these methods of legal enforcement. Now, having said that, I always find it a bit strange to talk about ethics. And I find it strange that these international bodies call the guidelines that they are drafting ethical guidelines, because what ethics used to be is something entirely different. It's not ethics, it's not something that is written down, and it's not something that is written down by governments or international organizations, but it's something that used to develop in the community as market practices or as social standards, standards of behavior among certain groups of people. But it's very strange to talk about formalized, drafted rules that some sort of experts have thought about as ethical rules, because they are written down and they have not developed over time. So in a certain sense, they are ethical because they don't have legal force. But in another sense, it's strange to call them ethical guidelines.
Thank you, Florian. There is a comment that maybe I can turn it into a question for you. It comes from Yvonne, that was commenting on this issue of trust, ethics, and legal. And basically she said, our clients to whom we deliver AI start trusting it when working on a daily basis. And she continues saying that, most interesting, our clients do not require many of the ethical standards that we are discussing in science. And then there's an interesting comment about that from Tobias that basically asks, do not require or are not aware of, it doesn't matter. So do you have any practical experience, maybe in other fields that is not AI, or how this is affecting the legal, the trust, being aware or not being aware, or what is your take on that?
That's an interesting comment and question. I would argue that it probably takes time, just because of the fact that I've just mentioned. These standards are not ethical in the sense that they have developed over time in the community, but they have been crafted by some sort of rule maker. And therefore, it will take a certain time until they develop into expectations of the market players. But I think over time they will develop in this direction, and it will often be argued that somebody who does not comply with these rules does not offer proper services. So if we look at them, these rules are very young, of a very young origin. They're barely a year old. So probably the time gap has just not been long enough in order to implement these rules into a market standard, if you want.
Yeah, thank you, Florian. I like to add that also education and is an important aspect.
Oh,
this is one of the reasons why we're doing, for example, this series of lectures, because it's making people aware. It depends on which role they have, from students to professional. When we are aware, then we are in the possibility to make decisions. So I think your presentation is also a contribution to make awareness of the subtle distinction between ethics and legal, and obviously is also connected to the technical space. So I would say this is really bringing all the three aspects that are covered in our lecture into one umbrella. So I'm grateful that we had that.
And in fact, it's not. I just mentioned the time gap between the rules and market practice, but I think it also has to do with the interdisciplinary nature of the field we are talking about. You have computer scientists, you have entrepreneurial persons, you have lawyers in the field, and the discussion among them has traditionally not been very strong, and therefore it takes a while until norms or standards can really develop from one field to the next, and it probably takes longer than within a homogeneous community. And therefore, it is so important to have lecture series like this in order to spread the word among these different communities.
Excellent. So let me conclude with I see that we have a few more questions. Are you accepting a couple more questions?
Yes, absolutely. And I try to follow the interesting chat, but
there's one from Tobias. I like that, because nonetheless of all this discussion, aren't legal rules in an ideal world manifestation of ethical or social stances of a society?
Excellent questions, and the answer that I would have given is already there. That's a really old discussion. The relationship between ethics and law. Now, of course, somebody has once said that the 10 commandments would be enough, and you don't need any legal rule books, and that shows somehow that ethics and law is close one to each other. But still, there are other examples where you can see that there is a difference. And the 1930s National Socialist regime is a good example of that, where the behavior of the Nazis has, to some extent at least, has been formally lawful. It was in compliance with the law, at least the taking over the power in Germany was lawful, but what happened was clearly unethical. And at that point, you see that there might be a difference also in substance between law and ethics. In an ideal world, I agree, law and ethics should be similar, if not identical, in substance. But in practice, you can have discrepancies, and you often have them, in fact. And then you have, of course, this functional difference that if some rules are only of an ethical nature, you cannot enforce them. That's something that I've mentioned extensively in my lecture.
Thank you, Florian. There's a question from Emily. The question is, do you have any reflections on the initiative to scope the future EU regulatory framework set out by the EU in their AI white paper? It seems to be setting out a path to develop legal rules in addition to the ethical rules. I think you cover it, but maybe you might want to comment that again.
It's more specific than what I've covered, but I entirely agree. The white paper is ambivalent, and also the other texts of the EU are ambivalent. They often claim to refrain from legal norms, but still they show that the EU is trying to aim towards legal norms. So it's when you read these papers, you always ask yourselves, what do they really want? Is maybe it's even kind of strategy of the EU to hide some rules in ethical principles, but at the same time they do want to point towards some kind of legal character. So it's a very hidden agenda that we might find there, and that's something I really want to criticize, because that's not a transparent and not very convincing approach. Even if the rules that they are drafting are convincing in substance, I think it's not very frank to hide them in such a way. Even if the real agenda, the hidden agenda behind is a different one.
Thank you, Florian. I'd like to conclude. So I'd like to thank you for this very interesting presentation. I'd like to thank, as always, our attendees for the very interesting question and the discussion we have. We will have a copy of your presentation and the recording online as all other presentation. So thank you very much, Florian, for your presentation, and thank you all for attending this lecture. And we're looking forward for the next week's lecture as well. So
thank you so much, Roberto, for having me. It was an honor to be here, and I'm really impressed by the audience and those many questions that have been asked. I sometimes would love to have similar students that are so active. Thank you.
Thank you, everybody. Bye then.
Bye-bye.